Good evening, everyone. My name is Patrick Hawkins. I am the president of the University of Tulsa Black Law Student Association. I'd like to thank each of you for coming. Um, the president of the Federalist Society, Ray Penny, also extends his greetings. He had an engagement that came up last minute and was unable to attend, but also would like to welcome each of you and thank you very much for coming this evening. Um, we have a number of very distinguished guests that we are very delighted to have, and I'd like to thank all of them for coming. As I reached out to them, and they were very responsive and very concerned about the issues that we'll be speaking about tonight. We've asked our own Professor Parker to be the moderator for tonight's event, and so he will be moderating the panel. But prior to Professor Parker speaking, we've also asked Mr. Chris Steele to attend, as he's been leading the initiative across the state for criminal justice reform activities, and it wouldn't have been at all in our best interest to have this event tonight without him being present. So, Mr. Steele, if you could come and speak for just a few minutes, that would be great.
It's great to be with you tonight. Thank you for the opportunity. I thank you for this forum. I suspect the discussion is going to be very enlightening and beneficial to everyone that participates. So I think this is fantastic. I'm going to try to be as concise as I can, give you a quick synopsis of where we're at in the state of Oklahoma and why we're working on these ballot initiatives that I think we have some volunteers. I know Lynn Powell and some others are here with the initiative petitions if you would want to sign them perhaps after the event. My story is this. I had the opportunity to serve in the state legislature for 12 years, and it was probably in my 8th or 9th year when I was given more responsibility over our state budget. And what I realized at that point in time, which would have been, I was elected in 2000, so this would have been 2008, 2009, I realized that spending for incarceration had become our state's second fastest growing expenditure. 2009, I realized that our prisons were about 99.3% capacity, and at that point in history, we were spending more for incarceration and incarcerating more individuals than we ever had in the history of our state. And so in every discussion and every debate and every decision I participated in reference to decisions for spending appropriations for incarceration or corrections reform policy, those decisions were made in the name of increasing public safety. And I was surprised to know that even though at that point in time we were incarcerating more people than we ever had, spending more money on incarceration, our violent crime rate continued to increase. And I realized that we weren't getting a very positive return on investment. Began to study what other states were doing to address the problem and what we could do ultimately to produce better results for the resources that we were appropriating to try to increase public safety in the state of Oklahoma. And here's what I realized. State of Texas, I suspect you're going to hear a lot of this from the panel tonight, so I'm not going to try to be duplicative. But what I realized is that we have to, first of all, differentiate between the individual who truly poses a threat to public safety and probably ought to be incapacitated because they're a danger to society versus the low-level offender who could be better served for less money through treatment, mental health care, and proper supervision in the community. In Oklahoma, we've had a long-standing issue of political consultants and elected officials who think that you have to be tough on crime in order to have a political career in the state of Oklahoma. I would submit and I would challenge that notion by saying that we can be just as tough and twice as smart if we'll just take time to consider the facts. And so we are presenting through a coalition that's very diverse. We call ourselves Oklahomans for Criminal Justice Reform, 2 state questions. State question 780 and 781. State question 780 is the policy question, and it seeks to reclassify drug possession and low-level property crimes from felony convictions currently punishable by incarceration to misdemeanors punishable by treatment, mental health care, and supervision within the community. That's the policy part of it. These policy changes would trigger cost savings by reducing our prison population by no longer sending low-level offenders to prison. State Question 781 then is the funding mechanism that directs the financial agency for the state of Oklahoma to capture the savings from reducing the prison population for nonviolent offenders, low-level offenders, and direct those resources back to counties to fund the treatment, mental health care, and job training that would be necessary to address root causes of criminogenic behavior. We believe, based on what has taken place in other states that have already enacted these policy changes, that by addressing the root cause of criminal behavior, we can first of all help people get healthy, connect them with the treatment and the mental health care that they need, and prevent additional crimes from occurring, which ultimately increases public safety, reduces crime, and makes better use of our state's resources. State Question 780 and 781, we have petitions here tonight if you would like to sign those petitions and help us give the people of Oklahoma an opportunity to vote on what we consider to be these very important policy changes. Thank you.
At this time, I would like to introduce William Otis. Mr. Otis is a graduate of Stanford Law School and has spent much of his career as chief of the appellate division for the United States Attorney's Office for the Eastern District of Virginia. During second President George Bush's administration, Mr. Otis served as counsel to the head of the Drug Enforcement Administration. He had previously served as special White House counsel for the first President Bush. Mr. Otis currently teaches as an adjunct at Georgetown University Law School and has had numerous opinion pieces appear in the New York Times Online, the Washington Post, USA Today, and Forbes magazine. He has also appeared on shows such as The O'Reilly Factor, Hardball, and 60 Minutes. Following Mr. Otis's presentation, I will be recognizing our panelists and providing them with 5 to 10 minutes to introduce themselves and share with us their points of view regarding criminal justice reform. Because of prior time commitments, Tulsa County District Attorney Steve Kunzweiler will follow Mr. Otis, and thereafter we'll hear from our panelists in a left to right order. Mr. Otis, welcome.
Thank you. I appreciate that generous introduction, and I thank you for it. And I appreciate the Federalist Society and the Black Law students inviting me to present what I strongly suspect will be a minority opinion in this room, and maybe the only opinion in opposition to what is called sentencing reform. Now, backers of sentencing reform are enthusiastic about what they see as its benefits. Thousands fewer men in prison for less onerous terms, reunited more quickly with their families to lead productive lives and become taxpayers instead of tax eaters. I will put to one side for the moment the naive view that I think this paints of people who get sent to prison and the behavior and, more importantly, the attitudes that send them there. I'll say only that in my experience as a federal prosecutor, I did not see family men caught up in a one-time departure from a productive working life. What I saw were men who from their teenage years on had a sketchy, if any, employment history, wanted a fast buck, and thought rules are for suckers. If they had children, the first time they had seen them, weeks, months, and sometimes years, was when their girlfriend, at defense counsel's urging, had the children brought to the sentencing hearing in the hopes of ginning up some sympathy. I want to focus at the outset on something reformers talk talk about much less, and that is the costs to the rest of us of shorter sentences and earlier release. As I'll explain later, the costs are certain to be stratospheric, given the staggering frequency with which inmates return to their criminal ways. But we don't need to look at recidivism statistics to see the grim story. We need only look in the newspaper. We tried a more limited version of sentencing reform in 2010 when Congress passed and the U.S. Sentencing Commission implemented reduced sentences for crack cocaine dealers and made those reductions retroactive. 2 months ago in Ohio, the paper The Columbus Dispatch described the results of one such case, and I will read parts of the story to you. The man charged with killing an ex-girlfriend and 2 of her children in a North Side stabbing rampage likely would have been deep into a 12-and-a-half-year federal prison sentence if sentencing guidelines for convicted crack dealers had remained unchanged. Wendell Callahan, 35, twice benefited from changes in federal sentencing, which reduced his sentence by a total of more than 4 years. Columbus police charged Callahan on Tuesday with 3 counts of murder in the deaths of his ex-girlfriend, Irvina Hammonds, 32, this is Miss Hammonds, Brea Hammonds, 7, and Anisha Green, 10. In a harrowing call to 9/11, neighbors implored police to hurry. One woman who was nearly incomprehensible in her grief eventually passed the phone to a man who said, "There's children with their throats slit." Hammonds and Callahan had a history going back more than 10 years. In a Columbus police report from 2006, taken while Callahan's federal case was pending, Hammonds said that he had beaten and choked her so severely that she thought she would have been killed if a good Samaritan hadn't come by. In the 2011 motion for Callahan's last sentencing reduction, his attorney said federal prosecutors agreed that Callahan's good behavior in prison led both sides to, quote, conclude that his early release did not present a danger to the safety of the public. Federal prison records show that Callahan was released on August 8, 2014. If the new federal sentencing guidelines had not gone through, he likely would have been in prison, at least until late this year, even with time off for good behavior. One may assume, as I will for purposes of our discussion today, that this horror of a case is a result of error rather than dishonesty by Callahan's defense lawyer and breathtaking incompetence by the prosecutor in the court. But for sentencing reform purposes, the mistaken is worse than the corrupt. Reformers will say correctly that any system we adopt is certain to have error, and we have no choice but to accept this fact. But they stop asking questions too early. Error is indeed unavoidable, with some sentences in our present system or any alternative system being too long, and others not long enough. Realistic questions, then, and the one reformers tend not to ask, are first, how grievous are the results of error? And second, who should have to bear its burdens? Should it be the criminal who made his own choices? Or the future victims who never had a chance? Errors involving overlong sentences are bad. There's no denying this fact, and there's no denying that they happen. But the nature of the harm flowing from the insufficient sentence in the Callahan case, showing what it can be, any change to the system that pushes more of the burden of error onto future victims like those two little girls and their mother, goes beyond being merely bad. In a country that values decency, it is not acceptable. In a way, though, the Callahan sentencing reform scandal is only the most recent illustration of a lesson we've been learning for 50 years. When we have more prison, we have less crime. When we have less prison, we have more crime. Ladies and gentlemen, we've tried this before. In the 60s and 70s, we made much less use of prison. We had a sentencing system with no guidelines and few mandatory minimum terms. We convinced ourselves that rehabilitation works and that we could trust judges with nearly unlimited discretion. We got something for our trouble. We got a national crime wave. In the 2 decades after 1960, crime increased by more than 300%. Whole neighborhoods in our major cities became free fire zones, largely because of the gunplay associated with drug dealing. There were 450 murders a week in this country. In the 1980s, all this started to change. We embraced stern, determinate sentencing for some serious offenses in federal law, firearms trafficking and drugs, including heroin and methamphetamine. A large bipartisan majority in Congress adopted mandatory minimums below which even the most naive or willful judge could not go. States followed suit, and the prison population has swelled. But the country got something in exchange for the reforms that made sentencing serious and honest. From the early 90s to the present day, we have enjoyed a reduction in crime to levels not seen since the baby boomers were in grade school. Crime has dropped 50%. It is down by half in a generation. There are 5.4 million fewer serious crimes per year in America now than there were a generation ago. Now, not all of this is because of the increased use of prison. Professor James Q. Wilson and others have found that about a quarter of it is, perhaps a little more. Some of it is due simply to the aging of the most crime-prone component of the population. Other measures that we have taken, such as more police, more proactive policing, and improved private security, have likewise contributed. But increased incarceration is a major factor in the significant drop in crime. Over the last 20 years, a fortune in costs to potential crime victims and enormous human suffering have been averted because of the millions of crimes incarcerated criminals did not have the chance to commit. These savings are seldom, if ever, accounted for in the cost reduction it is said that sentencing reform will produce. Nor, in truth, will there be much cost reduction at all. There will simply be cost shifting from government, where the supposed cost savings will loudly be advertised as tax frugality, shifting to future victims, disproportionately minorities, who will bear those costs in obscure silence. Let this probably be clear about what the somewhat gauzy phrase, sentencing reform actually means. It does not mean, as the credulous might think, an overall reformulation of sentencing theory. It means principally one thing: lighter sentences for felons. Those backing lighter sentences say they're needed not just for the supposed cost savings, but more importantly because the United States has just gone overboard on imprisonment. I think this embraces an odd misconception that the health of the criminal justice system is measured not by the crime rate, but by the incarceration rate. But if you'd ask people on Main Street, what's the problem with how we handle lawbreakers? How many would say, as sentencing reform advocates do, the problem is we have too many people in prison for too long? Some would say that. But I dare say the great majority would say, well, what's the problem? The problem is we still have too much crime. And they'd be right. We have 15,000, every year we have 15,000 murders, 84,000 forcible rapes, 750,000 aggravated assaults, and 1.7 million burglaries. According to Gallup, 1 in 4 households has been victimized by crime just in the last year. Now, it would be one thing if after release, inmates led peaceable and productive lives, but that's not what happens. According to a 2014 Justice Department report that surveyed 30 states, and I'm quoting now, this is Eric Holder's Justice Department, quote, within 5 years of release, 82% of property offenders were arrested for a new crime, compared to 77% of drug offenders and 71% of violent offenders. In other words, the huge majority, 3/4, of released criminals get back in business. With a recidivism rate like that, what shorter sentences and earlier release mean is simple: more crime faster. Sentencing reform advocates understandably de-emphasize this fact and instead point to programs reducing prison populations in states like Texas and North Carolina, among others, noting that in those states, crime has continued to decrease. I will leave it to you to decide whether what's happened in a dozen or so states over the last several years tells us more than what has happened in 50 states over 50 years. No one maintains that prison is the only thing that reduces crime, as I noted. In North Carolina and similar states, other crime suppressing measures have continued or accelerated. And after Heller and McDonald, we have more concealed carry laws for law-abiding people. We would thus expect crime to continue to decrease in those states, but at a slower rate as convicts hit the streets earlier, and that is what has happened, with 2 alarming and quite revealing exceptions. Last year, the murder rate in this country increased by 17%, and the heroin overdose deaths climbed to over 10,000. It is no exaggeration to say that sentencing reform, those who propose sentencing reform also propose to lighten the punishment for drug traffickers in the teeth of a cascading nationwide heroin epidemic. In any event, the supposed success of state efforts is often oversold by cherry-picking the areas examined. If one wants a more illuminating example of what happens when we do early release, it's not that hard to find. In 2011, acting under the Supreme Court's Plata decision requiring it to reduce prison populations, California has undertaken more early releases in the last 5 years than all the other states combined. It has done so, promising, as sentencing reform backers are wont to do, to concentrate on, quote, low-level, nonviolent offenders. Their performance has fallen short of the promise. The very next year in California, property crime was up 7%, violent crime up 3%, and murder specifically 5%. Car thefts were up 22,000 after having decreased for the prior 7 straight years. Nor is it just a matter of dry statistics. A 23-year-old college student in Los Angeles, Christine Calderon, was stabbed to death by Justin Kinnear 11 days after Kinnear was given early release. He was set loose to save the state money, notwithstanding that he had 40 prior arrests, 7 of which were for assault with a deadly weapon. He was still passed off as, quote, low level. Ms. Calderon's murder underscores the gravity of the decision before us. Sentencing reformers tell us that for years, the government has made thousands of mistakes about who to send to prison and for how long. In the next breath, they tell us that the same government can be trusted to make only manageable errors, manageable by someone else, about who to release and how early. When mistakes are made, as we know they will be, by the dozens or hundreds or thousands, who will pay the price? The government or the unsuspecting defenseless victim? Often poverty-laden, juvenile, elderly, addicted, a minority. Someone who, unlike the people in this room, had no say. But it's not just that practitioners of sentencing reform can't be counted upon to release only nonviolent inmates. There is a more radical core premise at the base of their argument that offenses not involving violence simply aren't as serious as our sentencing system has made them. For punishment purposes, however, the correct question is not just whether the offense involved violence. The question that matters is whether it involves harm. Nonviolent offenses do incalculable harm. The trafficking and consumption of hard drugs, for example, is one of the most socially destructive enterprises going on in this country, even when it occurs without direct violence. There's nothing violent going on when the teenage addict slides the needle in his arm, but if he gets the dosage wrong, he'll be dead by nightfall. There's nothing violent going on when a 9-year-old is enticed to pose for obscene pictures, but her childhood has been poisoned. There's nothing violent going on when an older couple is swindled out of their life savings, but their hopes for the future are gone. The siren song of the so-called low-level nonviolent offender will lead us into a swamp where people who can't afford law degrees will drown. I'll say one last word. I once thought that the ideas behind sentencing reform took root merely in forgetfulness about our enormous past blunders in the 60s and 70s and complacency about our success now in correcting them. But I think there's more to it. I think it's part of our country's recent pattern of settling for lower standards in the name of a toxic brand of equality. Increasingly, at home and abroad, we have turned away from America's strength and resolve and have discounted the interests of those who lead peaceable and law-abiding lives in order to cut breaks to people who don't. I hear the beckoning to a similar retreat in the call for easier sentences for the tiny and self-chosen minority of our people whose own criminal choices put them in jail to begin with. We're not the problem. They are the problem. Their behavior is the problem. Our system of stern sentencing has saved millions of people from being their victims. Complacency and softer standards are not the answer. Remembering and preserving what works is.
Well, I'm your district attorney. I'm Steve Kunzweiler, and I apologize for at least being the first person to step up to the lectern. I have one of my prosecutors who's a graduate of this law school who's being honored by the Women's Law Caucus at 7 o'clock as the lawyer of the year. And so I want to go and attend and honor Tara Britt for that great accomplishment. I'm a prosecutor and have been my entire career. That is coming up on 27 years in September. But I'm not the smartest guy in the room. I'm not the smartest guy at the DA's office. I'm not the guy that teaches law at Georgetown or some other great law school. I have the privilege of working here in Tulsa County, and what I do is work from my gut, which I tend to think is probably what most of us ought to listen to. I wrote down one word here because I think at its root, based upon the professor's comments, I think this is exactly what he's saying. Maybe I'm wrong. But it's wisdom. I think we have lost that word in our criminal justice system. I now see people who want to become judges because it's an employment or retirement opportunity. I today still can't envision myself being a judge because I don't think of myself as having the requisite wisdom to make the important, responsible decisions that are going to impact my community. What's the definition of wisdom? The soundness of an action or decision with regard to the application of experience, knowledge, and good judgment. That's what we need in Tulsa. I grew up in St. Louis. That's what my hometown needs up in St. Louis. I have friends in Detroit, and that's what they need up there. This problem that exists here is no different than anywhere else in this country. But we need to have the right people in the right positions to exercise wisdom, because it's the only way to solve the problems from here on out. I was fortunate enough to start my career as a prosecutor in Nowata County, and I met a judge who had wisdom, and many of you have heard me talk about Judge James Sontag. And what Judge Sontag would do with me as a young prosecutor would take me back into his office after I would screw up something in court, whether it's a direct examination or cross-examination or the application of a particular rule of evidence, and he would bring me back and say, Kunzweiler, when you're done writing down whatever you're going to write down on that file, you go ahead and do that in your office, and then you come back to my office, and we'll talk about the direct examination of a witness, or whatever it was I was going to get my rear end chewed out for that day. But I'll never forget the one lesson that he left me with, and I think this pretty much defines me as a prosecutor. One day he asked me, what was the role of a prosecutor? And I struggled with that answer because I gave him the answer that I thought everybody ought to give who would be asked that question. Well, my job is to read police reports, and as I read those reports, I decide what particular crime was committed, and I file that particular charge. Wrong. Okay. I went to the University of Tulsa School of Law, and I've learned the rules of evidence from Professor Chuck Adams, and so I feel pretty good at what I know in court, and so when I put that witness on the stand, I make sure I ask the right questions so there's proper evidence in court. Wrong. And then I fumbled around for the next couple answers. Each one met with a wrong from Judge Sontag, and at some point I said, I guess you got me, Judge. I don't know what my role is as a prosecutor. Right. You don't. I said, well, then elucidate me. And he told me this. He said, the role of a prosecutor is to teach the people the morals they either never learned or they forgot. And at that time I'm looking at myself. I'm a young father. I've got a kid who's 4 and another kid who's 2. And I go home to my wife, because Judge Sontag didn't explain that to me. But I'm sitting there thinking, what in the world does that man mean? I'm not a morals teacher. But then I started looking at, well, how am I raising my kids? What am I trying to do with my little 4-year-old and my 2-year-old to teach them responsibility? Because I want them to grow and live and be happy and be productive. And I started looking at what is discipline for kids. And if you look at it, what is discipline for kids? It's either a lecture, a grounding, or a spanking, right? Or you just completely ignore them, or you beat the living tar out of them. I don't call that parenting. But for the most part on the spectrum, it's a lecture, a grounding, a spanking. And so I then began to think, well, maybe that's the point of Judge Sontag, is maybe I need to look at each individual who's coming into my courtroom, that guy right there at that moment in time. Who is this guy? He's 27 years old. He's driving drunk. Do I just rubber stamp him like every other person that I rubber stamp and just give them whatever punishment? Or maybe I start digging and drilling down on this guy and figure out, how did you get to this point in the first place? Right? So with my kids, the lecture, you tell them, hey, let's not do this anymore. For the first time drug offender or first time DUI or whatever, you have that conversation, that meaningful conversation, and you hope you impact upon them, hey, we can't be doing this because it's going to turn out bad. For the spanking, that's an easy one too, right? As you raise kids, you know where the line's been crossed, and you say, you do that, your rear end's going to get lit up. For the child molester, you bet, goodbye. You're gone. I'm not spending any time with you, buddy. You're gone. You're going to prison. The hard people are the ones in the middle, the groundings. Those are the hardest decisions I had to make as a parent with my kids. And those are the hardest decisions that I have to do as a prosecutor, because I've got somebody that just keeps on committing stupid stuff. But I have to sit there and ask myself, how do I fix this guy? I've met, I think, maybe 7 sociopaths over 27 years. Those people you can't fix. The majority of the people that I meet are people that were born, came out of their mama's tummies, and I know their mom held them and loved them, I hope. And I know they had a purpose and they had a dream. I don't think people grow up to commit crime. So the role of a prosecutor, I think, is quite frankly what Judge Sontag told me, is you got to figure out, how did this guy forget what he did or what he learned? How did he not know that, right? Now, I've got some I could go on, and I don't want to drag this thing out. We have other speakers, but that's my 2 cents worth, because I think that's where we're at. So I want to speak to the senators or the representatives' proposition. Maybe a good idea. I disagree. I call it, quite frankly, the death knell of alternative courts and treatment programs. As I understand it, and Representative right here, yeah, you're literally taking every felony possession drug crime and making it a misdemeanor from here on out, right? Okay. I just know from common experience that I'm never going to get anybody to go through drug treatment court if their maximum exposure is a year in the county jail. I've got to have some kind of big stick at some point hanging over them so that they can understand that at some point, if you can't toe the line, you're gonna have a problem. And so, while I like the idea of maybe changing some of the ranges of punishment, there has to be a stick enough, big enough, that I can hold over that person to compel them to go to treatment. Right now, this law or this proposition, I think, is very much similar to California's Proposition 47. Pull up, Google it, Proposition 47, and you'll find out what California is inheriting right now. We've got people who are going and committing crimes, and they know that they're never going to be held accountable. You have deputies in Los Angeles who are just ignoring drug crimes because they just can't get these people to be held accountable. Why would they, right? As a parent, my kid marks the wall with a crayon, I'm going to discipline them. And if they continue to mark the wall with a crayon, I'm going to discipline them harder until I get their attention. Now, I don't want to put drug offenders repeatedly in prison, but, the reality is this, and this is why I think we have the problem. Oklahoma's kind of a 3 strikes you're out state, right? You commit your first crime, you can get probation. You commit your second time, you probably get probation. Your third time, you're not eligible for probation. You have to, by law, go to prison, right? And for back in the 50s and the 60s, that kind of made sense, because who was the habitual offender that you were dealing with? You were dealing with the guy who's committing maybe a burglary when he's 20. When he's 30, he's committing maybe a robbery. And when he's 40, he's committing maybe a shooting type crime. All of us could sit there and agree, that guy does not need to be on my streets. Get him out of here. But back in the 80s, when I first started becoming a prosecutor, going to law school, what happened to us? What was different? It was the onset of crack cocaine. And after crack cocaine, we got methamphetamine. And after we got methamphetamine, now we're doing with prescription pill, drug abuse, and synthetic drugs. What do all those drugs have in common? They are highly addictive. I call it the trifecta of the perfect storm. Highly addictive, ease of access, and very inexpensive. Never before, we always had drugs in the past, right? But never before could you make methamphetamine out of a pop bottle. Never before could you get addicted by crack cocaine because you could cook it up in a skillet in your kitchen. And we never modified our habitual laws for recidivism crime to deal with addictive problems. That's where our problem is. We got to figure out how to subcategorize the addictive crimes and separate them from the highly things that we're all afraid of. Murders, rapes, robberies, child abuse. That's where the fight's got to be. That's my opinion. So here's my solution. It's called End the Dysfunction. End the dysfunction. I'm a simple guy, like I told you before, but I can't stand it when I come into a courthouse and I can't communicate with my public defender because they're not operating on the same technology that I am. And I can't communicate with my court because they're not operating on the same technology that I can. And I can't communicate with 14 different law enforcement agencies because they're all operating on different technology systems. Nobody communicates effectively and clearly at the outset. I can pick the people I need to deal with, but when it takes all that delay and nobody knows who's on the same page, it's dysfunctional. So we need to invest in a system, and maybe we make Tulsa County, that's my pitch, make Tulsa County the project. Make it so Rob and I can work together. Make it so we can figure out how to solve this problem. You and I could fix this problem. We already talked about it, and we already are figuring it out. Coordinate your communication. Judges, quite frankly, it's called talk to your defendant. I was talking with Jill here just a little bit before. I'm sorry, I'm going on forever, sir. But it is offensive, pardon my French, it is offensive to me when I watch a defendant being sentenced in court, and this is the summary of facts, pardon me, Danny. This is the summary of facts, the plea form, right? Mr. Smith, is that your name here at the top of this paper? It shows that you're pleading guilty to the crime of burglary in second degree. Did you commit that? It says here on the back part of this page that your punishment range is 2 to 7 years. Do you understand that? Okay. Well, here it says that the state of Oklahoma has recommended a 5-year suspended sentence. That's your understanding of the plea agreement. Tell me what you did. And then the guy says, I broke into somebody's house with intent to steal property. Okay, thank you very much. Well, I'm going to give you that 5-year suspended sentence. I need you to go down this hallway, and I need you to sign your probation rules. I need you to fill out your rules for pay your fines and costs. You go over to this little office, and you do your Tulsa County work hours, and you check down at the DA's office, and wham, bam, you are done in a minute, ma'am. I don't talk to my kids like that. I do not discipline my children like that. What in the world are we doing when we talk with somebody who's committing a crime, who's 18, 19, 20, 25 years old? What lesson do they learn? There's no wisdom in that. None. I will gladly commit my prosecutors to work till 7 o'clock. And I told Jill this too. If we could work from 8 till 7 every day for the next 2 years, I would venture to say we could probably cut recidivism down just because we impressed upon them that we cared enough to talk with them and teach them the ways, but we don't. So talk with your defendant. Here's the other deal. You want to solve this problem? Pay your public servants what they're worth. A prosecutor, I'm sorry, if you are a law student in Tulsa County, I don't know what Rob's paying entry level. It can't be any more than me. But when you're coming in the DA's office, $40,000. There are police departments whose entry level police officers are making more than my prosecutors are, who are walking out of law school with $100,000 in debt. You cannot sustain a system with the turnover that I have because I can't keep the bright minds who can continue to problem solve. It takes 2 or 3 or 4 years just to learn how to do the job. And you want to keep that person for 5 or 10 years because then they can come up with these great ideas to help out Amy and Mimi, right? We would say, hey, here's my 10-year prosecutor. He's been doing this forever. He knows exactly what the problems are and he can problem solve. But when you keep on meeting the same new prosecutor, new public defender, you're frustrated, right? So pay your public servants what they're worth so they can stay here, so that Nolan and Brett can follow their passion. The only other solution I have is attack the problem at its beginning, right? Get these kids away from these homes that they don't need to be in. Help out these kids. You know, I'd love to be able to have the money that goes into the Department of Corrections and spend it on kids when they're 3 or 4 or 5, whatever it would take. If I could take 10 kids and look at them in grade school and say 3 of those kids are going to go to prison, I bet there are plenty of teachers in middle school right now or high school would say those 10 kids, I guarantee you, all 10 of them are going to prison. Teachers are smart enough to know that. If I can get in early enough to stop 3 of those kids, then it's not very smart math, but it seems to me I could affect prison population by 30%. It's pay the money on the front end. So, Representative, I agree with you. Pay the money on the front end, but we got to get after it early. Okay? Thank you for your time.
Can y'all hear me? Sure. I think they can hear me. I'm Damario, Solomon-Simmons. I'm an attorney at Riggs Abney Law Firm. I'm also the legislative liaison or lobbyist for Oklahoma Policy Institute. So I have a unique perspective because I'm probably the only guy in the state as an active litigator and an active lobbyist. I don't recommend that, by the way. I just got back from Oklahoma City. I just want to say something real briefly. I appreciate being here. It's a tremendous panel. I don't even know why I'm really here with all these great individuals on this panel. But for my first comments, there was a terrible case about what happened in Ohio. in the paper about the family that was murdered. But I would submit that as an exception to the rule, and obviously that is going to be highlighted in the newspaper because the newspaper is there to sell papers and for ratings. But we don't really talk about the success stories of individuals who get out of prison and go on to live successful lives because no one cares to read that because no one's going to buy that in the paper. I would also submit that the coinciding of the prison population explosion, particularly in the 80s and 90s, has less to do with the increase in crime and more to do with the so-called war on drugs, which we know was actually a war on black and brown communities, which is recently confirmed by an aide by President Nixon. And with that backdrop of racial disparity, then we must look at this system and reconstitute it if we're going to get back to the American dream and ideas of liberty and justice for all, which we're struggling with in today's society. Also, at Oklahoma Policy Institute, we have found in our studies and from other studies from around the nation that mandatory minimums do not effectively prevent crime. In fact, you have many organizations, including the American Corrections Association, which represents the largest group that represents prison guards throughout the nation. They would tell you that the prisons are overcrowded, and when they're overcrowded, they become more violent, and they're creating low impact or people with nonviolent convictions. They become more violent. They become better prisoners. And in Oklahoma, we have 1 in 12 individuals with a felony. And that example that our DA talked about, where you go in and you plead for a suspended sentence, that's a felony. And you don't realize that felony, you can't get housing, you can't get jobs, you can't get driver's license. In fact, your life is almost over. It's a life sentence. And so that prevents our society from having taxpayers to take care of their family, people that want to be family people. But now they can't work. They can't get a driver's license. So this is a problem that's really huge, and I think we must be compassionate and smart when we look at what's going on holistically and not just bring out the big, violent, heartbreaking stories of what happened in Ohio, but let's talk about this system. Let's deal with the facts. Let's deal with the statistics that we have and we can look at so we can move together and build the type of nation that we say we want, which is liberty and justice for all. Thank you.
Hello, everyone. My name is Adam Luck. I am the state director for an organization here in Oklahoma called Right on Crime. We're based out of the Texas Public Policy Foundation. We're a national initiative that works in states to advance criminal justice reforms based on conservative principles. I'm also recently appointed to the State Board of Corrections, so I've had an opportunity to visit quite a few of the state facilities and been privy to some information about the state facilities and the conditions that they're in and the numbers that we have right now. So that's kind of my background. I've been working in Oklahoma and studying the criminal justice system in Oklahoma for the last 2 years. Also studied Texas's criminal justice system and did some writing on that as well. So I think what I'd like to do is just provide a little bit of context, and I would agree with Mr. Otis's assertion that deciding what we do at the back end is very dangerous. It's potentially very dangerous. It's very difficult to determine what somebody's going to do once they're released. But I do think there's a distinction there again, and while, you know, I think the distinction still remains important, what somebody has done to get in prison. So I think that we have to recognize that we established the laws that determined who was a criminal and who was not. And I think that's an important distinction. We determined who was violent and who was nonviolent based on the laws that we created. I think that's a very important distinction. So I agree that deciding who's coming out and when they come out is a very dangerous job. But I don't think that is the only option. I think the smarter and more cost-effective option that we're talking about is assessing, should this person be going into prison in the first place? And actually, in Oklahoma, that's the decision that we're facing right now. So the Department of Corrections, we're at 123% capacity in our state facilities. So that's not just, this includes all the additional beds that we've added over the last 2 years. We've increased the capacity by about 1,400 beds. So that includes the beds in the day rooms, that includes double and triple bunking people in cells, 123% of the operating capacity. The actual, if you look at what the building was designed to hold, that's called the design rated capacity. That's when this prison was designed. This is how many inmates this prison was designed to safely house. That number is difficult to estimate, but it's closer to 140 or 150% capacity. In the last 20 years, our corrections budget has increased 172%. We went from $174 million in 1994 to $474 million in 2014. Over the same time, our violent crime rate has gone from below the national average to above the national average. Our property crime rate has gone from just above the national average in 1994 to well above the national average now, and most recently in 2014. So, I mean, I think the point is we're going to have to pay for something. You talked a lot about the cost, and I think that's an important thing to talk about. And the reality in Oklahoma is that we're paying for something and we're not really getting the outcomes. And we're also putting ourselves on a trajectory to a disaster, really. It's either going to be loss of life in one of our prisons, it's going to be overtaken, or we're going to continue to make the decisions we're being forced to make on the back end about who we let out and when we let them out. We're not making the more difficult decision of who should we be putting in the first place. That's really where we need to be focusing our efforts. So, you know, when you look at this whole situation, there's a couple key indicators that are really startling. So, one of the things that has been most startling for me is when you look at the numbers and you say, here's our corrections budget. It's increased a lot, but in comparison to the amount of inmates that we're now taking care of, the percentage of our population that's over 50 and the medical costs that we're taking on year after year after year, the aging infrastructure. We've got prisons that are well over 50 years old, and every single one of them has major infrastructure and maintenance needs that we've just simply had to put off because we haven't been able to afford it. And the one thing every year, the one variable that we're able to adjust is the staffing. That's the only thing that we can decrease the cost of. We can decrease how many people we staff in our prisons. You can't change how much it costs to feed an inmate. You can't change how much it costs to house an inmate. You can't change, the contracts for the private prisons are pre-negotiated. So when you look at the increase in our prison levels over the last 10 years, it's increased 26%. At the same exact time, over the same 10-year period, our staffing levels in our prisons have gone down 24%. We have, this is as of 2015, we have the lowest staff to inmate ratio in the country. The national average is 1 staff for every 5 inmates. In Oklahoma, it's 1 for every 11. If that isn't startling, and that trend continues, we continue to have more inmates, we continue to have less staff, our infrastructure is failing. You know, we have one prison where there's a boiler, and it's cost millions of dollars to heat and cool its facility. And we have an inmate who sits there. They sit in shifts, and their sole job is to watch the meter to see if it overheats. And if it overheats, they turn it off. And that's their job, because that's how poorly maintained that infrastructure has been over the last 30 years. And that is every single facility that we have, with very, very few exceptions. So my point would be, we have to pay for something. If we're going to continue to incarcerate people, then we've got to do that right. Because if we don't, if we continue to have low staffing levels, if we continue to not invest in maintenance and the infrastructure of our correctional facilities, if we continue to not invest in the hardworking people that every day are working miracles to keep this state safe in our Department of Corrections, then we're going to have a serious, serious problem. And if we want to do something different, then we need to invest on the front end. We need to do a better job of deciding, does this person actually need to belong in a very expensive, very costly, often not as effective means of punishment prison? And if they don't absolutely have to be there, let's look and explore what are some cheaper, more cost-effective, and actually better outcome-producing options that are going to keep our state safe, they're going to save our state money, and they're ultimately going to return these people back to society and help them live happy and productive lives. Thank you.
At this time, I'd like to pause the discussion and thank District Attorney, Tulsa County District Attorney Steve Kunzweiler for attending, and we appreciate your comments very much. Thank you.
Now you get to hear from Steve's ex-boss. Hi, I'm Tim Harris, former Tulsa County DA, 28 years in prosecution, a couple of years in private practice. The mission that we came up with under my administration was very simple: to seek truth and to do justice. And I really mean that from the bottom of my heart. I wanted to seek truth, I wanted my assistants to seek truth, and I wanted to do justice for the victims of crime that we represented. But you know, the DA and the prosecutor serves in a very special position. We not only have to care about what happens to our victims, but we really have to care about how we treat our defendants. And as they come through the criminal justice system, when I first started prosecuting in 1984, the decisions were really easy. You either went to the county jail, you went to state prison, you got a suspended sentence, or you got a deferred sentence. That's all we had, right? When I left at the end of 2014, we had drug court, we had DUI court, mental health court, women in recovery, community sentencing, 8,000 people in DA supervision. The options were enormous. And so what happened after I left, it was kind of like, you have to understand, prosecutors enforce the law, we don't make the law, right? And sometimes I felt like my hands were tied in trying to do what I thought was right by the law. And I read an article in the Tulsa World that the governor's office was formulating a criminal justice reform committee. And I checked on the participants on the executive committee. The Speaker of the House was on there, Senator Pro Tem, Scott Pruitt from the AG's office, the Director of the Department of Corrections, and the governor. And I thought, well, how can you have criminal justice reform without a prosecutor? How can you have real criminal justice reform without a public defender? Now, how can you have real criminal justice reform without the judiciary being there? You got three entities that are knocking their heads, you know, against the wall every single day looking to get good outcomes. And so I called and I tried to fight my way onto that executive committee, and I got denied. But I heard that they were going to have some subcommittees. So the squeaky wheel gets the grease. So I kept pounding on the door, and I said, listen, I've left the DA's office now. I haven't really started practicing law yet. I would like to be able to take my 28 years of experience and talk about policy, right? Why not take what I learned over 28 years? It's free of charge, right? I'll do it all myself. Well, I knew I couldn't do it all myself, but I got Governor Fallon to put me on the criminal justice subcommittee for sentencing. And I went in and talked to them, and I could see by the rhetoric that this was going to, what they thought in their minds was going to be a throwaway subcommittee. That there wasn't any way that you were going to get anything done on sentencing in Oklahoma, especially with our budget being what it is, right? I mean, look at where we're at right now. Although my heart goes out to Bill Otis has to say, the legislature ain't going to appropriate another dollar for another prison in the state of Oklahoma. I guarantee you that. It is not going to happen, okay? We can't even get the legislature to fund justice reinvestment that I worked with Chris Steele for over a year and a half when I was on the DA's council, okay? So you got to kind of look at where you can make some inroads. So my point of criticism was, okay, I can't do this on my own. Who am I going to have on this very eclectic subcommittee? I asked Rob Nye, public defender for Tulsa County. A guy I've gone head-to-head with many, many times. We've had lots of disagreements. But you know what? I respect his integrity. And I know what he's trying to do. Same thing for Bob Ravitz. I got Bob Ravitz from Oklahoma County, the public defender from Oklahoma County. Two largest counties in the state of Oklahoma. 51% of all felony crimes in Oklahoma are committed in two counties. Well, if we can make some inroads in two counties, we've helped solve the problem. Well, I looked at the judiciary, and Doug Drummond from the district court said, yeah, I'll come on your committee. Mike Fields, DA from Enid, Rob Barris, more rural community in Okmulgee, Angela Marcy from out in western Oklahoma, the AG's office. Adam Luck was kind enough to say, I said, Adam, you know, we'd like to hear some of your ideas. Ken Sudorfel from Lawton, I want the private practitioners there. And you know what? I said, listen, I know Rome wasn't built in a day, but would you be willing to give some time to change criminal justice for the better in Oklahoma? And you know what? Every one of those people said yes. So we started coming together, and lots of different philosophies came to the table, but I counted up the years in criminal justice, and we were long past 125 years of real on-the-ground criminal justice experience. And I just said, listen, the legislature is going to come up with some ideas whether we like it or not. How about we come together, the practitioners who've been doing it day in and day out for years, for me, my whole career, let's see if we can't bang heads behind closed doors and see if we can't come to some collaboration and some common ground. Well, we did. And much to the surprise of the governor's office, there was policy, treatment, policing, sentencing, one other subcommittee that I can't remember right now. We were the only committee that came up with unanimous recommendations. So all the bills that you see that Pam Peterson is carrying right now came out of our subcommittee. And I said, I've been doing this a long time. What are some things that we can agree on? And there was lots of things that, you know, we kind of came and pounded heads against, but these were some of the things that we said we could agree to. Discretion of the DA. Residue cases, right? You get a residue case, I'm required to file a felony because it's a Schedule 1 or Schedule 2. I'm looking at 2 to 10 in a residue case. How often did I feel like my hands were tied, right? And I can go through the litany. So we came up and we said, for any offense other than those enumerated in 21 OS 13.1, the 85% crimes, the prosecuting attorney, after considering the history, character, rehabilitative needs of the defendant, and in the interest of justice, may reduce the offense to an unclassified misdemeanor against the state, punishable by imprisonment in the county jail not exceeding a year or a fine not exceeding $1,000 or both such fine and imprisonment. Now, it gives the DA a lot of discretion, but with all the DAs and the public defenders and the private practitioners, we're going to get feedback from those sides, and with the adversarial process searching for the truth, we felt that there were DAs who were honest and ethical, who wanted to do the right thing in a case. Let's give them authority to bust felonies to misdemeanors. Well, if 1 out of every 12 people in Oklahoma is either a convicted felon or on probation for a felony, our workforce is decimated. How can you get a job when there's a box on your employment that says, have you ever been convicted of a felony? Yes. Well, you go in one stack and the non-felons go in the other stack, and you know how it works in the real world. Who gets the job? Does anybody get the job in the felony stack? No. We got to do something about that. How are we going to move forward economically if we can't even have a workforce? Another thing we looked at. I was an assistant when this happened, but we moved the felony floor, I'll call it, from $50 to $500. You all remember that? Right? You know, KCSP, Berg, all those crimes, embezzlement, all those crimes that had a felony floor to create it as such. I think we did that in 2001, and we haven't looked at it since. Well, the economy of scale has changed, right? That was kind of draconian in my mind, okay? And that doesn't mean I'm going to quit fighting or I expect prosecutors to quit fighting for victims, but to take that felony level from 500 to 1,000, and believe me, we battled long and hard, didn't we, Rob, to get to the $1,000. We actually started at 3,000. Because I think Texas went to 2,500, didn't they? So, I mean, you know, we're not reinventing the wheel. We're trying to look at other states that we think have had some good ideas on the table and have had some return on their investment different than what we were doing, okay? And that could we implement that in the state of Oklahoma? We also came up with burglary in the 3rd degree, forgery in the 3rd degree. We did keep knowingly concealing stolen property and false declaration to a pawnbroker of property taken in a residential burglary. It remains a felony. Why? From an evidentiary standpoint of view, anecdotally, if it's a false deck to a pawnbroker or a KCSP, you're probably the burglar, but I can't prove it. So I got you with the goods, but I can't prove you made the breaking and entering. So we agreed that those two would be taken off that list and would remain as a felony. We really talked long and hard about this. Drug possession, Schedule 1 and 2, right? 2 to 10 for your first go-around, 4 to 20 in your second go-around. We looked at mandatory minimums, and we said, in my experience, of the thousands, I mean, we file 12,000 criminal offenses in Tulsa County every year under my administration in the 16 years that I was DA. I'm not proud of that. I'm just telling you what the facts are, all right? And we looked at least 40% were drug-related. It probably tipped maybe 50, 55, maybe as high as 60, but you may not be able to gain that information through the interview process or what comes through the police reports. So if we have that many involved in using drugs and getting into other crimes, it's like I always said, I can throw you in the penitentiary for a second-degree burglary, but if you're doing it because you're a meth addict, you're probably not going to get clean and sober in the joint, and when you get out, you're going to be a better crook than when you went in. And have I really changed the way you think about life and your drug use? No. No. And so with all the alternative courts and the recidivism rate, which I think is better than the recidivism rate for those who are incarcerated, it's cheaper and you get a bigger bang for your buck diverting people from the penitentiary. So we looked at this and we said possession of CDS. I'm not sure this is in the bill. I have to see that. But within the discretion of the prosecuting DA, again, taking into consideration history, character, rehabilitative needs of the defendant, and the interest of justice, we can charge the first offense as a misdemeanor. If it has to be charged as a felony, we recommended that we take mandatory minimums off the table. So instead of 2 to 10 for your first offense, we recommended 0 to 5. For your second offense, we recommended no mandatory minimum, 0 to 10. On your third felony, simple possession, standalone simple possession, 4 to 15, fines to remain the same. We think that that will, over time, in a cost-neutral manner, where we're spending nearly $500 million a year on corrections and not getting a good return on our investment, I think that alternatives to incarceration in drug court and DUI court, women in recovery, all of the programs that I have seen the successes in, we have to look to those, because instead of incarcerating somebody for $20,000 a year and not getting a good return, I can spend somewhere between $5,000 and $10,000 a year and I believe get a better return on our investment for public safety, keeping a watch on somebody while they're still with their families, keeping their kids from going into the Department of Human Services, keeping their families together so that they can be taught, hopefully, values of right and wrong that Steve talked about. This is some innovative ways. And last but not least, community sentencing. Under the way the law is written right now, you have to be a convicted felon to become eligible. We said that's insanity. We have all these hundreds and maybe even thousands of criminal defendants who could benefit from not something as intensive as drug court, but they need more than just simple supervision. Community sentencing would be the key. So we said, let's create that glass ceiling of people getting into community sentencing and take that off the table. 5 out of 5 have passed out of the Criminal Justice Committee of the House and going to the floor. There's lots of ideas put out here, but I would just say this. Albert Einstein said, if you keep doing the same things over and over and over again, expecting different results, it's the definition of insanity. And I've been doing this 28 years, and I felt like my hands were tied many, many times. And so I think we have to come together as a community, ask ourselves, are we willing to take a chance on something that looks a little bit different? I'm a victim's advocate. You can look at my record. I'm not soft on crime. I don't believe these recommendations are soft on crime. And I'm just honored to be with such an esteemed panel to look for better ways to increase public safety and yet treat criminal defendants in our system. Thank you very much.
I want to ask that the panelists try to shorten their comments to about 10 minutes, if you allow me to open the floor for questions, or less.
Yeah. Professor Parker.
You got the hook on me, man.
Professor Parker taught me almost 25 years ago, and so I'm going to acquiesce to your request and be up here about 3 minutes and sit down. I believe I'm the lone federal representative here, and so I'm going to focus on kind of the federal side of what we're trying to do. We look at our statistics, and just to give you an idea, Tim's correct, They file 12,000 cases a year. We file about 250. Our jurisdiction is much more limited in terms of what we charge. We're not going to have the murders primarily or the rape and robberies. Those are not covered primarily by federal statutes. But the statutes that we do have in common and have some overlap are drug crimes. And so prior to August of 2013, the policy for DOJ prosecutors were to file the most seriously, readily provable charges in every case. And so what that meant is that if you had a 10-person drug conspiracy case, it didn't matter what your role was in the conspiracy. If it called for a 10-year minimum, you were going to be charged with a 10-year minimum. And so what happened is during that period of time, the Federal Bureau of Prisons population swole with drug offenders, low-level drug offenders. And I'll be honest with you, I do struggle with this term of nonviolent, low-level nonviolent offender, because I do believe that drug crimes are inherently violent. It may not be that kid on the street selling that rock, but it may be the supplier who wants to protect his supply that's going to go kill the other supplier. So I do believe it's inherently violent. But Attorney General Holder decided that policy needed to be changed, and in 2013 he came up with the initiative of Smart on Crime. And basically what that meant was we would, as prosecutors, look at individuals and do an individual assessment of every defendant that was charged in a federal drug indictment, and go through 5 or 6 criteria to make a determination on whether or not that person should be subject to a mandatory minimum. And as a result, 2 things have happened. One, our drug cases have fallen in terms of what we're prosecuting, and we're not subjecting low-level street guys to mandatory minimums. Now, I believe that in order to, and I don't want to get into the sentencing, that's above my pay grade. What we do is we prosecute cases. But I believe that you have to have a holistic approach to prosecution, right? You can't just have this mindset of we're going to put everybody in jail, because you're not probably 2% of the federal defendants get life sentences. So they're going to get out of jail at some point in time. And the issue is, what do you do with them when they get out? And so part of the Smart on Crime was also our reentry initiative, and it's been pushed. How do you get these guys reincorporated back into society? You know, they want the same things, I think, a lot of times, that when they come out, the opportunity to get a job, to try to get some education, if they go into jail, they probably come out with a drug habit. Can we get them counseling? And so those are the things that we've been focused on here in Tulsa, trying to have a robust reentry program. But I also believe, and I've seen it with the young people that we have indicted, and I'll be honest with you, every time we do an indictment, it breaks my heart, because not only are we affecting the defendant that's being indicted and probably will end up going to the penitentiary, it's spouse or girlfriend or significant other and the children that are going to live years without their parents. And then they're going to see that. And I can recall sitting in what we call Rule 11s. I don't know if Tim did those, but we sit in Rule 11s, and that's when you talk to a defendant. And I would ask, and I don't do this very often, but sometimes on some of our bigger cases, I want to sit on these Rule 11s, and I would just ask the defendant, tell me about your background. And what I found out most in common is dropped out of, in most cases, high school, sometimes middle school for sure, drug-addicted parents, right, and not a chance in the world, right? Rob and I had a case, right? And I was telling some of the guys in the office, Rob Nye is one of the best lawyers, I believe, in this city, and he serves as our public defender, but he also was on the panel. And we had a murder case, one of the very few that we have in federal court. And I was telling our guys that if everybody did what he did for that client, in both the state and the federal system. Our judicial system would be so much. He cared. He came in. He told us about this guy that we represented. Now I believed he was a murderer, and I told Rob that, and we punished him as a result of his actions. But I also realized, boy, this guy never really had a chance. And so I don't have any answers for you tonight. I can tell you that we are trying to make a difference. We are not going to incarcerate our way out of this situation. We're just not going to do it. And I think that for all of Washington's ills, at least at the Department of Justice, I think that we're recognizing that incarcerating everyone is not going to work at the end of the day. Now, the prosecutor tells me is you got to go to jail on some of these cases. There are just some sociopaths that just absolutely have to go to jail. And I don't care what you do for them, they're going to continue to sell drugs or commit murders. And so, but you got to be smart on how you do that. So I think this is a great panel. We're going to have differences of opinion. I don't know that we're going to walk out of here with any answers tonight. I like to get it off the paper and have more discussions, more than just discussion and action. And so anyway, I think that we're trying to do well in the federal system. It's tough. We are aggressive in our prosecutions, but we're also trying to be smart about it too. Thank you.
I'm Jill Webb. I'm a public defender. My position is a holistic defense coordinator. So what I do in the office mostly is try and connect our clients with services that they need to be successful on probation, which usually is mental health services, substance abuse services, mainly through Family and Children Services and other organizations around Tulsa. One of the things that really struck me about Professor Otis's comments were, this is just a very few number of people, right, that we're talking about we're incarcerating. I mean, for the vast majority of people who are law-abiding, we don't really have to worry about these people in prison, or if they're there too long. And I pulled some statistics here. First of all, it's a third of black men, a third. So it depends on what neighborhood you're talking about, if you think it's a lot or if it's a few, right? In Tulsa County, and this is from, I just pulled them from the Department of Corrections. So from 2005 to 2015, in Tulsa County, we sent 3,400 people to prison for simple possession of drugs. I'm not talking about possession with intent or trafficking or anything like that. 3,400 to prison. Tulsa County is 70% white and 10% black. And we use drugs at about the same rate. So you would expect, if it's a reflection of actual crime committed, that probably about 300 of those people who went to prison would be black, right? Well, actually, according to DOC, 1,386 of them were black. And that's 1,386 little bombs that went off in houses in Tulsa County, in African-American houses. So that's fathers who weren't there for their kids. It increased the chances that those kids would be incarcerated by 70%. It's women who are no longer with their kids, and those kids are in foster care or with some other relative at best. And it increased their chances of being incarcerated. This is not without consequences. This isn't something that we can say, oh, it's just a few thousand, we don't have to worry about them because they made bad choices and they used marijuana. Because some of these crimes, these people that we sent to prison for simple possession, is for marijuana. And the damage that we do to their lives and to their families' lives and to this community is real damage. And of course, some of those people are going to get out and do heinous things. We're people. That's always going to happen. If we locked up all men between the ages of 15 and 55, we could probably get rid of rape. And if we let them all out, some guys would rape, and we can say, well, we shouldn't have let them out. But we don't do that because there's harm in and of itself for incarceration. The second thing is that one of the things he asked is who will pay the price for the sentencing reform. And who's paying the price now is poor people. Our clients, in the public defender's office, we only represent people who can't afford an attorney and who can't bond out. That's 80% of felonies that are filed in Tulsa County. 80% is against the poor. And so what they do is they're incarcerated in Tulsa County Jail when they're booked. And then the next chance they have to plead, and usually it's a probation officer, probation offer from the state at first. The first chance they have is probably a month after that. So they've been in jail, and they live close to the edge anyway. So they've lost a job if they had it. It's gone. You can't just not show up for a month. Their families, God knows where their kids are. They've lost their house. They've been evicted. Their pet, everything is gone. So when they have that chance to plead, they plead because they get out that day. And then they're walking around as a second-class citizen because they're on probation for a felony. And then they're watched, and they have thousands of dollars in fines and costs. They're indigent anyway. They get nothing for the fact that they've spent that month in jail. They don't get a break on the fines and costs. They don't get a break on community sentencing. By and large, they just get not only incarcerated, lose everything, plus they get punished, right? There's a cost to that, not just to those people, but to their families and to the community that could depend on them, right? And part of the problem is, and I don't think that necessarily the law enforcement or anything else is full of racists. That's not what I'm trying to say. But for example, and I know I'm going to be fast, but it's not unusual for law enforcement to be on the north side and stay by a stop sign. And so everybody who rolls past a stop sign is stopped. They'll ask to search the car. They'll see if they smell, liquor or anything like that. If they don't have a driver's license, the car is towed. It's search subject to tow. And so they get lots of things. They get guns, drugs, DUIs. If their kids in the car, then it turns into child endangerment, lots of stuff. If they did that same stop coming out of Southern Hills Country Club, right? Then they would also get all those people, DUIs, people have been drinking beer and playing golf and things like that. And moms have their kids in the car. She might have had some gin and tonics while they were swimming. You could get child endangerment there. God knows you get really great cocaine and some, pills and all this sort of stuff. All of that, right? It's the same thing, but we don't do that. That would last 30 minutes before that happened because somebody would make a phone call and that would be like, my God, constitutional rights and all this sort of stuff. This system depends on it being performed on the powerless. And it's not right. And we shouldn't wait until we're treating rich people like we treat poor people because that's not ever going to happen. And it shouldn't. What we should do is treat poor people like we treat rich people. We should give them an opportunity for rehab. We should not try and just catch them because what the North Side feels like, I think, is that they feel like their police force is containing them and the South Side feels like their police force is protecting them. And you can feel it in their relationship. And it doesn't serve anyone. It doesn't make us ultimately safer because we need a good relationship between our neighborhoods, every neighborhood, and law enforcement because that makes us equal under the law. My God, that's why we're here and that's why we care. That's why we went to law school. That's why I went to law school. So, one other thing, because I know I'm coming up on 9 minutes. And I love Steve Kunzweiler. He went over and he said, "I'm so sorry I have to leave." And I said, "Maybe we can have lunch later." So, but I did want to, and I think he's a good, decent man. But I really disagree with him on him saying that his role or the role of a prosecutor in general is to enforce morality, and that's because 35% of the people who come into Tulsa County Jail are so mentally ill that they have to have psychotropic drugs. 35%. Of our clients, they self-identify as 65% self-identify as having a substance abuse problem. And substance abuse and mental illness are not moral issues. They're medical issues. And that's how they should be treated. Thank you. So, but he's a good man, and I want to have lunch with him, but we really, I do. We're just really disagreeing on that, and I'm really enormously honored to be on this panel, and I have a great boss. Everybody keeps. Anyway, thank you. Thank you.
Good evening, everyone. Good night. My name is Marvin Lizama. I also call myself a criminal defense attorney here in Tulsa County, thankfully because I had the great privilege of not only graduating from this fine law institution, but having the guidance of incredible people along the way, like Mr. Nye, of course. We all have to pay homage to him because he is a great attorney. I'm glad that I followed Jill Webb because what I wanted to say is very simple. We live in the age of discrimination, and discrimination abounds within the criminal justice system. And we see it in every aspect of the criminal justice system. We see it in the number of people that get arrested, that get charged, and that get sent to prison. And what we see is a disparity of how this system is being used against blacks and Hispanics. And in Oklahoma, against women. And so when I say discrimination, that's what I'm referring to. There is nothing wrong with having a criminal justice system to punish individuals who commit crime. That's obvious. But the point is that the reason why for instance, I am in favor of anything that will take place and replace the system that we have is because of the disparity of how the system is being used against blacks and Hispanics. I too have a bunch of research that I did for this, but we're not going to bore you with that. I wanted to make sure that I deliver my position on it, and that is the racial disparity under which we are sentencing minorities, blacks and Hispanics in particular. I'll give you some figures instead of trying to bore you here. But for instance, here in Oklahoma, the statistic is for the years of 2007 to 2011, for crack cocaine alone, 82% of African Americans who were arrested for that went to prison, compared to only 14% of their white counterpart for the exact same crime. We have here in Oklahoma alone an 8-to-1 ratio of blacks who are sentenced to life without parole for the same and similar crimes as their white counterpart. 8-to-1. Disparity, discrimination. That's the problem with the system. That's what we have to fix. Thank you.
At this time, I'll open the panel up to questions from the audience.
I wanted to, and anybody can answer this. I'm just a lawyer practicing in this town, and obviously student, but I mean, how do you, and Adam, you address the cost primarily of the recipients of a sentence when they go to a prison in this state. Like, how do we finance the cost and improve the quality of our criminal justice in this city or in this state? But this state doesn't even give a damn about its educational system. We have one of the worst educational systems in the country. They don't even want to finance that. They don't even want to pay good teachers. So what Mr. Kunzweiler was saying about pay the civil servants, I totally agree. We don't seem to appreciate that here. I grew up in St. Louis, same place that
Steve did. I'm not saying it's a better place, and I went to high school in Ferguson. You guys heard about that place, but I don't understand it. And I've been practicing here in the state for a while. Rob and I worked on a case for a while. Anyway, I don't understand why we don't take this seriously and we don't want to do better, because that is the key component to getting our criminal justice system in all facets, from the courts to the alternatives, to the sentences, to the prisons, to the people and the staff of the United States Attorney's Office, who I really like practicing in federal court, Danny. It's the best place in the world to practice. Nothing against everybody here from the other state offices and county, but this has been a quandary in my mind, and I just shake my head at it sometimes, especially when elections roll around. It's like, what's the use? Can anybody talk about that, or maybe not?
Well, I would just say this, okay, you're gonna spend your money one way or another, and I agree, our educational system needs to be looked at, and I'm with you. I'm trying to figure out a way how to free up some corrections money so that we can divert it to education or whatever other priority we, the people, tell our representatives about how we want our tax dollars spent. And so I think rather than $20,000 for every year that somebody's incarcerated, there are no free lunches. If you give me somewhere 5, 7, 10,000, half of what it costs to incarcerate, I can give you, I believe, a better return on your investment the way that person gets treated once they go through the criminal justice system and the court system. And so, again, over time, I think we're trying to take the valve off of the economics of such to where we can build and have more fungible money that can be used for other reasons. But you're right, we have to tell our legislatures how we want our tax dollars prioritized.
Sorry, go ahead, sir. Let me say a couple of things about cost. As I was pointing out, we now have 5.4 million fewer serious crimes in the country than we did a generation ago. That is a huge cost savings to the people who are not victimized by crime. Now, because it's private individuals who are not victimized by crime, those cost savings do not show up in a government ledger, but the fact that they are less visible does not make them less real. The second thing I would say is that there aren't actually going to be any cost savings, and again, I would point to California, the largest state by far that has tried sentencing reduction. What actually happened is the criminal justice budget, instead of going down over the course of 3 years after realignment was implemented in California, they were spending $2 billion a year more. And the reason they were doing it is not that there were false promises about relief. The releases occurred. The problem is that the government didn't stop spending the money, they just started spending it in different places. And that's why in places that are more compatible ideologically with the administration than in power. But the taxpayers never saw a dime.
I'd like to take a shot at that as well. So your question was, how can we even talk about funding corrections when we can't fund education? I think one way to look at that is, what's the impetus for change? Why would we invest in corrections? I think that's why this problem is so sinister, is because the evidence for needing to address this problem just really isn't there to the average person. So let's take, we talk about California, let's take Texas as an example. In 2005, there were projections that their state inmate population by 2010, in 5 years, was going to increase by 17,000 inmates. That was enough for their legislature to say, I'm sorry, but we cannot afford to build 2 new state prisons to house those inmates. We have to do something different. And they did. They invested, at the time it was $241 million into developing alternatives to incarceration, to incentivizing the creation of drug courts, and investing in a number of other areas as well. That was in 2007. So they had a reason to invest. They did that. Fast forward to today. So they've maintained their lowest crime rates since 1973, both violent and property crimes. They've saved $3 billion since 2007. They've closed 3 state prisons. They've closed 8 juvenile facilities, and they've cut their juvenile population by 52%. So that's another example. That's another state that's done that. So that's the problem here in Oklahoma, is that we're never going to have a state inmate population that increases by 17,000 inmates in 5 years. But we are going to have a state inmate population that increases percentage-wise just as much. And that's the problem, is that it's much more subversive. It's not going to cost us that much as it would in Texas, but it's still comparatively going to cost us a lot of money. And until our legislature and until the people of Oklahoma really understand the severity of the problem that we're facing right now and the trajectory that we're on, it's not going to change. Until something really serious happens, I think that's not the case.
And I just want to say, not in rebuttal, but I totally agree with you and Tim. Your comments are very instructive. But our legislature and the way people think here in this state, supposedly we're the reddest state in the country, which means we're very conservative. But any kind of reform effort, alternatives, and things like that, other than putting people in the slam all the time and sending them to prison, mandatory sentencing schemes, and all that, I mean, it's never gonna go over too strong in this state. The change has always been incremental and barely gradual. But, I mean, I do believe in these things that, you gentlemen have talked about tonight, and I've done a lot of research on it myself, as I'm sure everybody on this panel. We keep up with these kind of information tablets that come out all the time. But our legislature in this state, I mean, as you pointed out, Adam, don't get it or what, or they won't do anything. And they're always selling some tagline about everybody needs to be more afraid than, you know, doing things to make adjustments and reform our system and cut the costs.
In my experience as a lobbyist, the main thing that elected officials hate more than anything or gets them more excited is when they have someone running against them. So I would encourage people, if you want to get the public discourse out there and get your point of view, to run. I mean, look at Bernie Sanders on a national level. He may never win, but he's been able to really influence a debate. So that's something that does not happen enough. In fact, at OK Policy, we were able to track that almost 75% of the individuals that got reelected in 2014, they didn't have anybody running against them. They just went right into office. And so more people have to run. Sometimes a win, I'm a former football player, I believe in wins and losses. But sometimes you have to define what the win is. Is the win necessary that you're going to be actually elected, or is the win to get the conversation changed in a way to have this discussion that we're having in a very limited space, but in a larger arena?
I have two other questions.
My name is Drew Ware, and I'm an attorney in Poto, and I represent the detention center there, which is a county facility. But I have a background of, 7 years as prosecutor and 20 years as public defender. And one of the things that Jill Webb touched on just lightly that you may want to look at, Mr. Harris, with your group, is she said the defendant has been arrested. He sits in jail for 30 days before he appears in court, before he has a bond set, but there's nobody advocating for him to get that bond reduced or to get him an OR. And your county jails are suffering because we're sitting there with people that we can't afford to house, that if they had an attorney and the attorney could go in and get the bond reduced, he would be out and back to work and with his family. And so we've got a glitch in the system there, and it's addressed a little bit in an article in the American Bar Journal by the president of the American Bar Association right now, who is a lady of American of African descent. And she talks about the importance of looking at the defendant and his assets as you set the bond. Because, just setting a bond for $1,500 for a crime, a small crime, that may be a third of the guy's annual income. And if you can get the guy out of jail up front through some changes in our bonding processes, then he can go back to work, or he can be with his family, even if he does come around later to get a public defender. And right now, the fast rule in most counties, I believe, is if he bonds out, he's not eligible for a public defender.
Exactly.
And that doesn't work. Well, then the next step of discrimination that I used to see as a public defender was I had a prosecutor who was kind of born with a silver spoon in his mouth. And he would come to me and he'd say, well, if your client will pay $800, we'll dismiss this case, or we'll reduce it to misdemeanor. And he thought that was a good deal. And if you have $800, it was a wonderful deal. But if you have a public defender and you don't have 2 cents, you feel like you've been cheated and discriminated against based on your poverty.
Well, the federal system is so much different than the state system. There really is a presumption of innocence. Actually, no. There's a presumption that you're not detained in the federal system. And so if we indict someone and issue a summons, for the most part, we don't do perp walks in the federal system. We'll send you a summons. Sometimes if we need to, we'll do an arrest warrant. But the presumption is that there conditions imposed, to let you out. And you actually never put any money up to bond out in the federal system, which is really interesting. And I asked a career prosecutor, so why do they do that? I was used to the state system because of the long arm of the federal government. But actually, it's what the Constitution says. It's you're presumed innocent until the government proves that you're guilty. And the bond, unless you're a danger to the community or to yourself, the bond should be there to ensure that you're going to return back to court. And so what you see in the state system is sometimes used as a punishment before the punishment. In the federal system, I really do, and we are very selective when we ask for detention, because we'll get, slapped down by that magistrate,
Another question in the back room.
Yes, I want to be really brief, but I just want to say I've been practicing law for 40 years, and when I got out of law school, the rumor was that there was no such thing as a debtor's prison, and that's been proven wrong. But I really have a question. I'm sorry that Steve's not here, because Representative Steele made a passionate plea to sign this ballot initiative petition, and Steve basically left and said he was against it because he felt like it would reduce his discretion or ability to get somebody to go to a drug court or maybe one of these other courts that I think have been very beneficial to this community, to everyone. So I'm wondering, what is the answer here?
I have a thought.
Okay.
If someone's a drug addict and they're charged the first time as a misdemeanor for methamphetamine, for example, people think that if you're a meth addict, that you're just living the high life and the only way you're going to be punished is by the criminal justice system. But the punishment for being a meth addict or a crack addict is being a meth or a crack addict. There's an automatic incentive there to want to go to treatment. And the heartbreaking thing isn't that it's a misdemeanor or a felony, it's that there's a waiting line. If they actually want to go to treatment, then it's 3 months. But if they can go to jail and turn themselves in and do it that way, but we're funding the wrong thing. So it's not as if people are without incentive to get off drugs. They want to get off drugs. And as somebody who's a defense attorney, I've spent thousands of hours with felons. And it's a perspective that the DA doesn't have, right? Because they spend it with files. I spend it with people. They want help. They do. Just offer it, and you don't have to put them in jail for it.
An addendum, not just files, victims also, okay? It's just not the file, all right? That's not why I went into public service. Just like you, I went into public service to serve people and to work with people.
I didn't mean any disrespect. I'm sorry.
Okay.
It's good as lawyers, we like this.
At this time, I'm going to have to turn the program back over to the president for closing comments.
Exactly. I'm ready for a beer now.
I see that we have a few more questions. We said that we go until 8 o'clock, so we'll give it another 10 minutes. And if you guys want to stay longer, that's fine. We'll stay as long as you wish and answer your questions to the extent that the panelists would like to do so. So,
I'm enjoying.
who will ask? What is your question?
So I am curious, was it intentional that no one except for Jill mentioned marijuana specifically? I wanted to see, especially since the state questions that we're talking about that are up specifically addresses marijuana. I just want to hear a little bit more about what you all think in terms of sentencing.
I think marijuana should never be filed as anything other than a municipal ticket. That's my opinion. I think that wasting penitentiary time on simple possession of marijuana, which happens more often than you would imagine, is a ridiculous waste of money. And it's less harmful than alcohol that I don't.
It's still illegal in the federal system.
Come on, Steve, lighten up.
Well, we have pictures of our president doing it, so
So I'm
Well,
just curious.
I think that, look,
We do?
I know he
we don't make
but I
laws,
didn't think we had
we
pictures.
enforce those laws. But I would tell you is that I think the Department of Justice has, tried to, go after the most, dangerous criminals that they can. Congress decides that marijuana is not, illegal. I suspect if you got 400 pounds of it, we will prosecute you for it.
Well, you probably need to be prosecuted if you got 400 pounds of it.
But for the record, it is illegal.
Legal.
Unless it's for personal use.
My experience when I was sitting with the feds,
Medicinal.
which was some time ago, was actually in the last millennium when I was an assistant U.S. attorney. But if an agent had come to me wanting to prosecute in federal court a case of simple possession, I would have suggested that he maybe take a vacation. We'll do trafficking, and we did do trafficking, and even in the two states, Colorado and Washington, that have made recreational marijuana legal as a matter of state law only. Trafficking is still illegal in those states. I think there is a slight consensus in the country now in favor of the legalization of simple possession of marijuana, but that there is not anything like that support for legalizing trafficking.
Any other questions?
Like many of you, I also was a public defender, and I just wonder if anybody would like to take a stab at addressing, to me, what seems like an obvious one solution, may not be the only solution, but removing the profit from incarceration, from jails, from housing people, because we all know the statistics were pretty clear that when the jails became privatized, allegedly crime increased, the number of, we had to fill the beds. So is there anybody who would like to address that factor?
I'm not sure about if I can address it sufficiently, but I don't like private prisons because they make money filling beds, not on empty beds. Okay, there's a real problem with philosophy behind there, right? I listened to Jill's numbers. The Department of Corrections told me when I was prosecutor that we had 438 first-time simple felony drug possessors that were in the penitentiary. And I said, I want to know every one of those defendants. We pulled every one of those cases. And so I don't trust the stats from the Department of Corrections. We showed them to a T to every one of the cases they said was first-time felony possession, that there was other crimes involved with it, found out that count 1 is the controlling count. So we changed our policy in the DA's office that the most serious crime became count 1 because that was the classification with the Department of Corrections. I mean, there's so many things with the stats that I really have a problem with. And so, we've got our hands full, but first-time felony possession marijuana, Lord forbid that anybody, when I was DA, went to the penitentiary for that. It had to be not a standalone crime. A count 2, a count 3, 3 violent felonies on the second page, some other historical or factual information that leads to the incarceration rather than the standalone possession of marijuana, because like you don't kill a gnat with a sledgehammer.
To get to the cost aspect of the point about poverty, I was recently in a meeting and learned, and we were looking at some legislation to make it illegal to lock people up for fines and fees, which is happening every day across our state. And I didn't realize, but 54% of the DA's budgets come from fines and fees. And so it makes it very difficult for DAs to want to give that revenue source up because of the issue of not being adequately funded by the state. When you put on top of that civil asset forfeiture, where they're taking people's property, when they pull them over, and who they're pulling over again, poor people, black people, Hispanic people. So that is a major issue that we have to continue to deal with. That's why I always think we have to look at it from the poor and also from racial disparities. And I really appreciate what Marvin said. Discrimination is happening every single day within the system, which requires, once again, that we look at holistically trying to reform or create something that's better and new and better.
I have a question just to follow up, and my question is going to be actually directed to Speaker Steele to answer. I know you've got your hand up trying to get in to talk. So we obviously have that problem, right, in Oklahoma, that corrections and public safety is funded at 11% of the overall state budget, where education is funded at 51%. We've got district attorneys' offices who are funded at a fraction of the cost, and DA Harris, DA Kunzweiler can all tell you that, you know, they're doing more with less and can't adequately staff the offices. Other state agencies are suffering the same problem. Part of the revenue fix, right, even though we're in revenue failures, is to assess the cost, or essentially tax those fees on the backs of the defendants. And right, wrong, or indifferent, that's the system in which we live. So you've got DA's offices who are funded and getting reimbursed for the first 2 years, having to supervise for 2 years. You've got drug courts, the alternative courts that are largely successful, that are predominantly funded by the fees paid by the participants in that court. My question to you, Speaker Steele, on the state questions is, how do you respond to DA Kunzweiler's assessment that the state questions are a death knell, right? What is the incentive for a defendant who is looking at entering into a probationary type sentence in a drug court, where they're going to have to pay money that they don't have to participate in a system for a lot longer, whereas they could take, if your state question passes, a reduced sentence from what they would be looking at now in terms of taking away the mandatory minimums or reducing the maximum range of punishment, and in a system in which the Department of Corrections is housing inmates for a fraction of the sentence that they actually get, or those that fall under the Justice Reinvestment Act, which I believe you authored, they're getting cut and released within 90 days on an ankle monitor. So what's the incentive for a defendant that says, I could sign up and pay $2,000, $4,000 that I don't have over the next 2 years, where I'm going to have to go to treatment and meetings and have people constantly looking over me, versus I'll sign up for a 6-year sentence and be out in 90 days on an ankle monitor and discharge it, and the DA's office doesn't have any paper time that they can revoke me. What's the incentive?
The incentive is this, and it's a paradigm shift. It's exactly what Jill said. It's treating people with mental illness and addiction disorders as being sick. So we're getting them the health care that they need. We're not legalizing, we're not decriminalizing, we are reclassifying. We're saying that the punishment should fit the crime, and we're saying that if you're sick, if you're ill, and you need medical help, if you need treatment for your illness, for your sickness, for your condition, we're going to match you with that. I don't know anybody that wants to be a meth addict. I've never met them, and I work with them every day. Every day, that's what I do in my real job. And so this is a paradigm shift for the state of Oklahoma to say, instead of locking people up for being sick, for having a problem, we're going to get you the help that you need to get healthy. Your assessment is exactly right. I'm a huge proponent of drug court, and it is a phenomenal program if you can afford, as a participant, to do it. But it's expensive because you're paying for your treatment, and it's not accessible to everyone. Now, there's some other diversion programs, maybe community sentencing, maybe some others, but mental health court and drug court has become very, very expensive. It's almost become a rich man's game. We now have the funding, if these state questions pass, to make it affordable for everyone who needs it, not just for those who can afford to do it. So we're saying you're sick, you're going to get help. That's what we're saying. We don't lock people up for other diseases. We don't lock people up for having high blood pressure or for having heart disease in Oklahoma, but we certainly do for mental illness, and we certainly do for addiction disorders. And so we're not talking about manufacturing, still a felony conviction. Distribution is still a felony conviction. Those are dangerous crimes to society, but for the person who has a substance abuse disorder or a mental illness, we're saying we're going to get you help. We're not saying that it's okay to use these illegal drugs, But if that's your only issue, we're gonna get you help. Treatment doesn't work every time the first time. That's what the research says. Sometimes you relapse. That's not okay, but it doesn't mean that you're a bad person either. We're not gonna put that felony conviction on you for life that's gonna exclude you from participating in any sort of pro-social way within our community. It's a paradigm shift for the state of Oklahoma, and we're gonna have to rethink some things. But it's about getting people and connecting people with the help that they need to get healthy and to be productive citizens within our community. And just to speak to what my friend said in the row in front of me, if you're unhappy with the way that the legislature is thinking, this is your chance to send a message. This goes directly to a vote of the people. And I will just tell you that the stakes could not be higher. The thing that keeps me up at night is knowing that if we're successful in November and these reforms pass, we have the opportunity to work on corrections reform in the state of Oklahoma for the next 10 years because the legislature will feel like the people have spoken. Consequently, the reverse is true. Our initiatives fell in November. This issue is off the table for the next 10 years because the legislature will feel like the people have spoken. This is our chance. We've based these reforms, we've done our homework, we've based these reforms on states like Utah. We're based these reforms on what's happening in the state of Alaska, very similar to what's happened in the state of Texas. And we're not only reclassifying simple possession and low property crimes, we're also providing a source of funding for counties to be able to fund the treatment components necessary. If a county wants to put an inpatient treatment program in the county jail, they're going to have the funds to do that. So I'm not just sitting in a jail cell, I'm getting the help I need to get healthy so that I can go and be a contributing member of my community. Sign the petition.
Where is it?
Right down there.
I'm gonna go ahead and close after that. We'll take one more question. Shoot.
No, I didn't have a question.
We're gonna go ahead and close. I wanted to make one statement as the president of the Black Law Student Association, just explain our intention tonight. First of all, we wanted to be sensitive to the fact that there were issues that, as we're here in Tulsa, there's the social side of this issue, criminal justice reform. There are people that this affects them, this affects their families, and of course we're concerned about the Black community, about minority communities, about women. But also, with my experience before law school, having been a Marine Corps veteran and then spending 16 years in corporate America in finance and consulting, I understand that one of the first things we were taught to do when we look at a process, and this to us as a consultant is another process. And one of the first things that we were taught to do is to take a step back at any process and look at it and get an understanding of it. But the way we were taught to get an understanding of the process is to talk with the people who are the practitioners. This table that you have in front of you is the equivalent, if I were in consulting, of over 100 years worth of experience I would be able to go to, get their participation, get their input. And then when I was sent to the board of directors, I could come up with feasible solutions. So in order for us to realistically address the concerns that we have here in Tulsa, and for us to realistically reform the criminal justice system, we have to know what the opposition or what the voices are that we'll encounter on our way to that goal. So there's no way that we can fix the system per se, or realistically address criminal justice reform unless we have the conversation with Tim Harris, unless we have the conversation with Steve Kunzweiler, Dan Williams, and the practitioners in the system, so we can go to them with realistic solutions. So it is obviously our intention to get all of the diverse aspects of the different points as they pertain to criminal justice, but also hear the voices of the community that are concerned with the impact across the board. With that said, we want to thank you all for your participation tonight. Thank you very much for coming. Thank you very much. A hand of applause for our panelists.